for 2 weeks time.
What? I can't hear you.
Lordship,
Louder. Mic is on.
Lordship, I pray for 2 weeks time.
Why?
For orders on office notes, select to Mr. Arvind Kumar Jha.
Lordship, I pray for 2 weeks time.
Yes.
I pray for 2 weeks time.
What? I can't hear you.
Lordship,
Louder. Mic is on.
Lordship, I pray for 2 weeks time.
Why?
ऑफिस नोट में हुजूर क्या है नहीं देख पा
नहीं देखा आपने. कोर्ट मास्टर आपको फाइल नहीं देते? आपसे फाइल नहीं मांगा इन्होंने?
नहीं, ये तो नहीं माने.
आप ठीक 10:30 बजे आए या पहले आए?
पहले से आए.
All right, we'll see the office notes and pass orders. लिखिए. By the order of the court, notices were sent to respondents number 4 to 7 under both processes. Stop. Notice has been received by respondent number 5, which is taken as valid service of notice. Stop. So respondents number 4, 6 and 7 have not been served. Stop. As such, it is directed that the appellants take further steps, for issuance of fresh notice on respondent numbers 4, 6 and 7 within a period of 2 weeks. By furnishing requisites along with the correct and present address of the aforenoted respondents, returnable on, give a date after 6 weeks.
Lordship, in this matter, the notice has been sent, but only of the IA, not the copy of the LPA, Lordship.
17th of
That's
August.
right. We are hearing on the IA first. We'll see.
17th of August.
Stay already granted to him.
In the stay matter.
Stay already granted, Lordship.
That's right. So therefore, we will see whether the order requires any change. Aisa likho. Then let fresh notice. You accept notice on this? Likhiye. Though notices were issued only on IA number 1 of 2019 to respondents number 4 to 7, but only respondent number 5 has received such notice. The counsel appearing for respondent number 5 accepts the notice in the main appeal. Let fresh notice be sent in the appeal as well as the IA to respondents number 4, 6 and 7 on steps being taken by the appellant within a period of 2 weeks, both modes, along with correct and present address, returnable on 6 weeks.
17th of August.
Okay.
Select 3 Mr. Dhananjay Misra.
Mr. Counsel for the appellant, you serve a copy of the main appeal to him also.
Lordship.
Because I have declared in the order that he receives notice
Lordship.
on LPA also. So
Lordship.
give it to him.
Lordship.
Select 3 Mr. Dhananjay Misra.
Yes, Mr. Mishra. You are appearing for Bata India. Yes, Sheila Devi. You are appearing for Bata.
No, Your Lordship, I appear on behalf of the state.
Yes.
I am appearing on behalf of the appellant.
Appellant is the daughter or wife of the main employee. Yes, tell us what is to be done. Why should we interfere with this order?
The husband of a appellant has appointed on 26th April.
Mr. Mishra, those facts are not in dispute. Now, if you repeat those facts, perhaps you would be consuming your time and the time of the court. Now, tell us the list. Where has the single judge gone wrong? Where exactly, which part of the order offends you? Or which part of the order offends any law? Or it's a factually, the decision is based on factually incorrect statement. Tell us something like that. We will take notice of it. Now, is it a fact or not that you remained absent, of course, under treatment for more than 18 months? Right?
Obliged.
So therefore, under Rule 19, there is the power is given to the employer to discharge your services because you may not be found to be fit for any industrial employment. Now, therefore, any order of reinstatement was bad. That's what the single judges held.
The appellant has submitted the medical fitness certificate, Lordship.
That's not necessary. That's not necessary. You join only after 20 months.
Yes, Lordship, but so far this matter is concerned, Lordship, the appellant has given the medical fitness certificate provided by the ESI, Lordship, and then after, Lordship, completely that is violation of natural justice, Lordship, in which he was terminated, Lordship, and so far this appellant is concerned, Lordship.
Sorry, we can't interfere.
And one thing, just Lordship, I would like to submit before Lordship is that the judgment of Honorable Supreme Court, Lordship, in which by the paragraph number Ranjit Thakur versus Union of India and others, Lordship, 1987, SC6, I permitted to read some important lines, Lordship. The Supreme Court cautioned that even though the choice and quantum of punishment is within the jurisdiction and discretion.
That's on a totally different issue. Ranjit Chaudhary is it's a judgment authored by Justice T.S. Thakur.
Ranjit Thakur and
Justice T.S. Thakur has authored that judgment. That's on a different issue. That's on the issue whether the quantum of sentence imposed upon a delinquent employee, can that be interfered with by courts of law? It's on that issue. We are not considering that issue here in your case.
And one thing,
Ranjit Thakur is a good judgment. You must read it. You must know the principles there. Right?
One thing I would like to submit before the Lordship is that so far TF and gratuity is concerned, nothing has been paid to the.
That's a different issue altogether.
And
you go before the authorities, go before the person concerned. Whatever is due shall be given to you. But reinstatement and payment with full back wages is what we don't.
One thing I would like to submit before Lordship is that a person who is suffering with tuberculosis, Lordship, and who is a doctor, a team of doctor's team has not provided the fitness certificates, that will be the violation of natural justice. How can a person who will join when he was suffering with tuberculosis, Lordship, and when he got the tuberculosis medical certificate, Lordship, he has gone before the authority, Lordship. But after 3 or 4 months later, a person who has given a service more than 27 and 28 years, Lordship, and when he has suffered with tuberculosis and arrived before the authority.
Very unfortunate, Mr. Mishra. We have all sympathies for Sheila Devi, who is the wife of Rama Prasad Gupta, but nothing can be done about it. Give that judgment, we will deal with it.
He's quoting from some other judgment where the broad principles are given. He's not giving the 87 SEC judgment.
Let him give whatever he is offering to the court. That's his discretion. The court, if he has the right to argue, he has a right to argue something which is non-existent also. It is for the court to accept or not to accept, Mister. Take that. Heard Mr. Dhananjay Mishra, learned advocate for the appellant, and
Rohitab Das,
Rohitab Das for the
AG.
state. We have not issued any. Has Bata India been noticed?
Yes, notice is given,
Though,
but not appear.
Though Bata India Limited, through its general manager, was earlier noticed by this court, but there is no appearance. on its behalf. The husband of the appellant had been appointed on permanent basis at Bataganj Digha factory. On account of his illness, he remained absent from duty for a long time, for more than 20 months continuously. Because of the aforesaid absence of the husband of the appellant from duty for more than 20 months, he was proceeded against under Regulation 98 bracket Roman 3 of the Employees State Insurance bracket General Regulations 1950 bracket में लिखेगा hereinafter called the regulations. The husband of the workman was put to notice, which he refused to accept. Later, on a separate notice, on a separate notice, the workman replied, intimating the management that he had been on sick leave from 1/11/1993 till 21/7/1995, when he was given medical fitness certificate certifying that he is fit to resume duty with effect from 24/4/1995. The management, however, chose to discharge the workman by the order dated 13/11/1995 under Regulation 98 bracket 3 of the regulations referred to above. The matter was referred to the Labour Court under Section 10(1)(c) of the Industrial Disputes Act 1947 for adjudication whether the termination of services of the workman was justified, and if not, to what relief was he entitled to. It appears from the records that the Labour Court pronounced an award on 2/8/2007 holding the termination of the workman to be indefensible, and thus the order of termination was set aside. The management of Bata India Limited was directed to reinstate the workman with full back wages and all other consequential benefits. The aforesaid award was challenged before this court by CWJC number 3337 of 2008. By the management on the grounds that there was nothing in the award which indicated any unfair or improper treatment to the employee, or that the domestic inquiry report was in any manner perverse or unsustainable in the eyes of law. The provisions contained in clause 19B of the standing orders of the management company was also brought to the notice of the learned single judge. On the aforenoted grounds, it was, in the first instance, urged that the referral by the state government of the matter to the labor court was improper, and the consequent award unsustainable in the eyes of law. We find from the impugned judgment that the learned single judge took note of the Industrial Employment (Standing Orders (close) Act 1946. What did I say?
We find from the view judgment that the learned single judge took note of the Industrial Employment (Standing Orders)
Which provision concerns, which provision governs the conditions of employment of all permanent workmen subclause B of clause 19 provides that no workman will be discharged for protracted illness unless his absence on that account exceeds 6 months, and provided that the workman has, from time to time obtained leave from the company. The relevant regulation of 98(3) of the regulations referred to above further indicate that if the condition of service of any employee so permits, an employer could discharge or reduce the rank on due notice to an employee who has been under medical treatment for some of the diseases which have been notified in the regulation, but only after the employee had been under such treatment, only if the employee had been under such treatment for a continuous period of 18 months or more. On a conjoint reading of clause 98 and clause 98 of the regulation and 19B of the Industrial Employment (Standing Order) Act of 1946, the learned single judge rightly came to the conclusion that in the event of the workman remaining absent from duty for having suffered from tuberculosis for more than 18 months, he was liable to be discharged, as according to the management he would be unfit for any industrial employment. The contention of the appellant that in view of the medical certificate by the ESI hospital to the workman that he is fit to join duty, he ought not to have been discharged, is not worthy of acceptance. What is relevant is not the fitness of an employee on the date of discharge, but of his remaining absent, though under treatment for more than 18 months in one go. The learned single judge therefore found the award setting aside the termination of service of the workman and directing for his reinstatement with full back wages from 1990 to 12/11/95 was not sustainable in the eyes of law. We have found no impropriety in the domestic inquiry and therefore the observation of the learned single judge that without the domestic inquiry, without the outcome of the domestic inquiry being assailable on any count, the award passed by the labor court was not sustainable in the eyes of law. Thus, in view of the findings of the inquiry report in terms of regulation 98(3) of the regulations referred to above and clause 19b of the standing order, we do not find any flaw, any fault line in the judgment passed by the learned single judge. We are thus constrained to dismiss this appeal, but without any order as to costs.
See, one thing an observation may be given for the granting of gratuity and
That is not prayed for.
Any other, it would be open for the appellant to approach the authorities for payment of the rightful dues of the workman if it still subsists, if it has not yet been paid. ये कौन सा जजमेंट आपने दिया रंजीत ठाकुर वर्सेस यूनियन ऑफ इंडिया? किसी केस में रेफर हुआ केस को आप दे रहे हैं. दिस इज नॉट द वे यू साइट जजमेंट्स मिस्टर मिश्रा. You have, anyway, we are not going to tell you how to do. Dev Singh and G. Gyanayutham, these are most important cases of 1970s. Now, in some judgment it was quoted and you are giving that judgment to us. If you want the court to look into all this, you need to give the judgment 1987 4 SCC. Is this a judgment authored by me?
Yes,
no, Justice Upadhyay.
I believe it's by your lordship.
here's the lordship order.
All right, return it to him.
Obliged.
Seal
Yes.
for Mr. Sardan and Misra. Seal for Mr. Sardan and Misra.
Lordship, in this case, I pay for 3 weeks' time for converting miscellaneous appeal in criminal revision, Lordship.
Look here. The counsel for the appellant seeks 2 weeks' time to convert the present appeal into one under revision under section 19 subclause 4 of the Family Codes Act 1984. Stop. Permission is accorded. Excellent. Permission is accorded. Stop. If necessary modification is made in the cause title, the registry shall place the case before the appropriate court, subject to the approval of Honorable the Chief Justice.
Seal for Mr. Ranjit Kumar Yadav.
Your Lordship, just I have received the counter affidavit responding to 124 letters. So,
The appeal stands disposed of with the aforesaid liberty to the appellant. Yes.
Your Lordship, just I have received the counter affidavit responding to 124 letters. Lordship. So, आज भर के लिए
You have received counter affidavit.
just I have received, Lordship.
Then that's all right. Just you have received is all right. Now, Have I heard this matter before?
Yes, Lordship. Earlier, my lords were pleased to heard this matter. My lords, on day 1 itself, I had requested a lordship.
You appeared for respond number 5?
1 to 4, Lordship.
Have you filed your response? All right. The learned counsel for the appellant submits that he has received the counter affidavit on behalf of the response number 1 to 4 and 5 only today in court. First off, he wishes to go through the same and respond if necessary. First off, for the aforesaid purpose, he seeks a short adjournment. Re-notify this case on 2 weeks.
No, 1 week, Chair. Tomorrow will also.
एक सप्ताह के बाद.
My lords,
13th of
my
July.
lordship, my humble request was that my lords, state government is also necessary party in this case, lordship, because
Don't worry.
in case of any,
We don't worry. We are only concerned with respond number 5, the controller of examination.
my lords,
Now we'll see.
that is the principle of the college, lordship.
Whoever he is.
Lords,
Whoever he is.
lords.
And then if we find that excluding the appellant was not justified, we will direct the government to do the needful.
Lordship, my
Don't
lords.
worry about the state being a party.